Hi, good afternoon. If you're here for the Vinson and Elkins Grant Analytics Navigating Series, you're in the right place. Welcome to our program. My name is Zach Terwilliger, and I'm a partner here at Vinson and Elkins in our Washington, D.C. office in our government investigations and white collar group. Thank you again for joining us, and let's get started. I'm going to turn it over to my good friend, Brandon Sessions.
Thanks, Zach. My name is Brandon Sessions, and I'm the Vice President of Commercial Cybersecurity for Gray Analytics. And I have the pleasure this afternoon of introducing Stacy Bostjanick. Ms. Bostjanick is a member of the Senior Executive Service and serves as the Chief Defense Industrial Base Deputy Chief Information Officer for Cybersecurity. Take it away, Stacy.
Great. Hi, Brandon. Hi, Stacy. Everybody, thanks for joining. My name is Jamie Tabb. I'm a partner in the government contracts group here at Vinson and Elkins, and I'm going to be moderating the discussion with Stacy today. And Stacy, we really appreciate you doing this and joining us. We know you have a busy schedule, but I think, and I know all of the participants and we all appreciate having inside view of how DoD is thinking about the CMMC program. So really appreciate it. So just to get us kicked off, there may be some folks listening in who are either new to DoD contracting or haven't been paying much attention over the last few years. So can you give us just at a high level, what is CMMC exactly?
Okay, so I'm going to give you a little bit of history as we start. So, in the beginning, right, there was a clause that came into being December 30th of 2017 that said that you needed to comply with the NIST 800-171 requirements if you handled the department's covered defense information or controlled unclassified information. So that clause actually came into being around 2014, but you had until 2017 to be compliant if you handled that data. The problem that we had was we had a DoD IG audit, and then we also had the Navy Cyber Readiness Review that went out and looked at companies to say, how are they doing in their compliance? What we found is they weren't, right? We found companies, I think the requirement in the 12 clauses to have a system security plan and a POAM to get there. And we found companies that copied and pasted a system security plan off the internet and still had insert company name here. And then they also had POAMs that weren't going to be closed till 2099, at which point I'll be dead. So that was not acceptable to the department. And so at that point in time, Secretary Shanahan said, hey, we've got to figure out if the companies that are handling our sensitive information are actually doing the things that we've asked them to do to protect that data. And we have seen resoundingly since that time and today, the number of incidents being reported from our industry partners are doubling almost every year. They're constantly on the rise. And, we've lost the design of things like our F-35 and our F-22 to our adversaries. They've come in and they've downloaded these designs and they haven't had to spend a dime to develop it themselves, when we in this country spend billions of taxpayer dollars to develop these exquisite capabilities that give my son and daughter who are of military age, and your son and daughters that might be of military age, the exquisite superiority in armed combat. We're losing that, right? Because we developed these things and now other countries are able to download them through cyber attacks in 15 minutes. They don't have to develop anything. So that brought about the need for the cybersecurity maturity model certification program, which is a way to validate that companies are actually compliant with the requirements that they've been expected to be compliant with since 2017. Long story for a short question.
Yeah, I appreciate it. That's it's good to have the history. And just so I'm sure most people listening in know the acronym, but when you say POAM, you're referring to a
Plan of
plan of.
action and milestones, yes.
That's great. Thanks so much. So obviously, we all know, or most of us know, that a final rule was issued in October of last year for in the DoD section of the Code of Federal Regulations, in the
For
Title
32. Yeah,
32,
yeah.
right? So given that that final rule has been issued, can you tell us a bit about the current status of the program and what comes next?
Yes. So when we started CMMC back in the first Trump administration, so it is an initial Trump administration initiative. A lot of people like to say it's a Biden administration initiative, but no, it's a Trump administration initiative. We originally thought we only had to do the 48 CFR, which is the DFARS rule. What we found out is when we did the strategic pause, when the Biden administration came in, that we really should have done a 32 CFR, which it codifies the rule, I mean, codifies the program in a rule, right? And so that 32 CFR gives you the details all the way down of how that program's going to work. We will not, because we're not a regulating agency, we will not be able to put it in on industry's lap until the 48 CFR, which is the DFARS clause, allows us to include the requirement in your contracts, right? So today the program stood up and it's good to go. If a company wants to get their certification today, they are able to negotiate with a C3 PAO and get certified. You will see RFPs coming out. We hope probably, I know the Army has one that's supposed to come out in August that they would like to include a CMMC requirement in. If that 48 rule, which is continuing to move through the rulemaking process, completes by August and is published, then we will be able to start including it as a contractual requirement. That is a pre-award requirement. It didn't make good business sense for it to be a post-award requirement, even though a lot of companies asked for it to be, because it can take companies 6 months to a year to become certified. Nowhere have I ever seen a program that is budgeted and has the execution rate that allows you to wait for a year for a company to become certified before we can begin effort on a program. So it will be something that will have to be achieved prior to award. You do not have to be certified at the point where you submit your proposal. However, proposal bid and proposal time frame and source selection time frame is usually only a couple of months, and it takes a little bit more than a couple of months to begin and end the process of becoming compliant and certified. Even though I will say we recently met with a large cloud service provider that was working with a MSP on top of it, that took a company from zero compliance to 100% compliance in 2 months, and then they got their certification. So it can be done. They utilized a cloud uh, environment to get there, but that they did get it done in 2 months.
Gotcha. And you mentioned one other acronym, which we'll get into more
Sorry.
with the C3PAO, and these are the third-party assessment organizations,
The
correct?
CMMC third party assessment organizations, because as you know, FedRAMP has three PAOs. And the funny story was, when we were working this at the very beginning, we met with A2LA and the FedRAMP people. And when we were considering calling our third party assessment organizations three PAOs, they kind of turned their nose up and they said, "We don't want yours to have the same name." So I said, "Fine, we'll call them CMMC third party assessment organizations, C3PAOs," which that was, if anybody remembers, right when we were working on the Jedi program for the department. So I thought that dovetailed nicely. We kind of got that, Star Wars vibe going.
Right. I like it. I like it. Um, so you mentioned that CMMC was actually a creation of the first Trump administration, and It's kind of one of the rare initiatives that has continued to progress through both the initial Trump organization, the Biden administration, and now the second Trump administration. But obviously, there's a lot in the news about everything going on with the executive orders, Doge. So, in your view, has the new administration been supportive of continuing with the progression of CMMC?
Yes, I think they are very supportive. I think while there is a desire to reduce the burden on our industry partners and regulation, the recognition of the amount of data that's being lost and the impact that that has on our military capabilities and our superiority is kind of earth shattering from one perspective. I mean, this is when I always laugh and say I'm going to start playing I'm proud to be an American in the background. But when you think about the fact that the whole reason why we are here in OSD and in the Pentagon is to provide a capability to the young men and women of this country that go out every day to secure our freedoms for us. And it makes no sense that I'm going to not bother to protect that sensitive data that could possibly save their lives in an armed conflict. Right, and the other thing is when you look at the NIST 800-171, and undoubtedly I'm an acquisition and contracting person. I am not an IT guru. Okay. I'm not your typical CIO person, but the CMMC is based on a validation that people are complying with the 800-171. And that 800-171 is not the creme de la creme of cyber protection, right? In fact, oftentimes people will be like, well, if they had been CMMC certified, could they have stopped a nation state actor from hacking them? No. They probably would be aware that they were being hacked, right? And so, the hard part is when we started this program with the 800-171 way back in the day before we ever figured out we needed a CMMC to validate you were doing it, the whole concept was not to be overly onerous on industry, right? But to get the basic protections down. And we originally were going to have industry comply with what we comply with in the department, which is the 853, which is far more extensive, which covers confidentiality, availability, and integrity, right? And now we're just covering the confidentiality part. Eventually, we're going to have to get to the availability and integrity. Think about it, right? We don't have the all those protections in place and required in our industry partners. You have a weapon system that is important to us being able to win an armed conflict. Or how about this? Support our allies. Think of the weapons that we're sending to Ukraine, right? And we have to produce those weapons to be able to send them to Ukraine. And our adversaries figure out one of those members of that supply chain is vulnerable and they shut them down. What happens to that weapon system, right? We can't produce it. We can't get it in the hands of the warfighter that needs it. These are important things for us to do. And I don't think people actually pay attention to the correlation of what this is protecting and helping us moving forward.
Right. Yeah, no, and I think you've anticipated some of my other questions, which is kind of generally why does DoD see CMMC as important, and why is it so important for contractors to comply? I mean, the clear answer is this is a national security issue, and it's
Oh,
just,
most definitely.
yeah.
Yeah, well, and look at what we do and put in place today and what we expect people that are handling our money to be how what kind of compliance we're looking for there. How about the people who are handling our medical information, right? We have high standards for what their cyber is supposed to meet so our personal information doesn't get hammered all the time. And this is our military information, right? Now, it's the unclassified part of it, right? It's not the secret or top secret or confidential. And, there was one thought at one point when we had the Protecting Critical Technologies Task Force, well, maybe we should just uplift all this information and make it confidential or secret, right? Which it was, if you go back through history in the day, it was at a higher classification level, which impeded our ability to share and partner with industry because it made communications difficult. So that's why they went to this form, to be able to enhance that partnership with industry, to make sure that we had the communications back and forth. But when you start looking at all this information, if we don't protect it, then our adversaries can draw at least understandings of what our plans are. If not, they can also download the designs for our weapon systems.
Right, right. Given that we have the 32 CFR rule, but we do not yet have the DFARS rule, should contractors be doing anything now to prepare for the soon to be released DFARS rule?
Well, it's kind of like jury duty, right? You got to do your civic duty, and it is a requirement today, right? Because you have signed a contract that said that you're willing to be 800 171 compliant if you handle our data. And so, to that end, uh, companies need to be moving in that direction. I will say, if you have been doing the wink, wink, nod, nod, I've got a poem out to 2099 thing, and haven't really gotten started, look and pay attention to who you're working with. Make sure you do your research. There are large cloud providers out there that are providing environments that will help you get 800 171 compliant for a fairly reasonable amount of money and in a fairly short amount of time. Right. So if you're unwilling or disinterested in bringing something within your own network, then take a look at those. If you are interested in making sure something in your network, you can either do an enclave or you can do an enterprise, right? And you need to draw the boundary of where you think that CUI transits, right? Because it's, if you store, process, or transmit CUI, you have to have that area protected. Figure out what that is, make sure that it's compliant. We have assessment guides out on our CIO website. There's Project Spectrum, there's DC3. There are different resources available to assist companies in moving towards that end. Start working towards that today, right? Don't wait. Get out in front of it. One of the guys, they had a CMMC West, and they had a video of a guy who said, I was like, wow, what do I need to do? He started Googling to figure out how to meet the requirements, right? We have our assessment guides right out there on the website you can look at. Uh, do those kinds of things. There was a guy, Jacob Hill, had on LinkedIn a blog post where they talked about, with a man that went and he got his company compliant, right? And he said, had I known then what I know now, I could have saved my company $400,000, because you don't have to spend that much money to be compliant. A lot of it has to do with the way your network is configured. Go find that blog and listen to it, right? There are people out on the Cyber AB website has resources and capabilities out there. They list the people that are consultants that have been through the training, that know exactly how to help you get NIST 800 171 compliant. If you use a C3 PAO as your consultant, you cannot use them as your assessor. So pick who you like for what role, and employ them. But I would say it's a national imperative that we as a nation get on top of it, right? I mean, I don't know about you, but how many times have you been told that your social security number's been stolen? How many times have you been told that your personal information's been stolen, right? They're not doing it just for the fun of it, to say, hey, let me see if I can steal this, right? They're planning to use it against us at some point in time. And we all owe it to ourselves, right? And if companies get 800 171 compliant, it doesn't just protect my data, it also protects your intellectual property, right? And think about it. If our adversaries could get a hold of the recipe for Pepsi, they'd probably be pretty interested in having that, right? Because they could make a ton of money, or Coke or whatever, right?
That's really helpful. Thank you so much, Stacy. We're have a bunch of additional speakers here, so we're going to try to keep on schedule. But this was very informative, and thank you again for taking the time to share your thoughts with us.
Anytime.
Great. I'm going to kick it over to my colleague Tyler Robinson, who has some slides he's going to go through, and we're going to. Stacy talked about some of the kind of high-level requirements. Tyler's going to dig in so that everybody listening can have a fuller understanding of the nuts and bolts. So Tyler, why don't you go ahead and walk us through the key elements of the CMMC program as described in the final rule.
Yeah, sure. Thanks, Jamie. And thank you, Stacy, for sharing those insights from DoD. So my name is Tyler Robinson. I'm a counsel in the Vinson and Elkins government contracts practice. And as Jamie said, we thought before we continued on with the rest of the panel, we thought it would be a good idea to briefly recap what those CMMC requirements are to frame the rest of the discussion. So next slide. So Stacy already talked about this, so I'm not going to spend much time here, but essentially CMMC is DoD's program to ensure contractors are adequately protecting the sensitive information they receive under DoD contracts. So CMMC itself creates new assessment and annual affirmation requirements to verify that contractors are meeting their cybersecurity obligations before the award of a prime contract or subcontract. So the cybersecurity obligations, the security controls that the contractors have to meet, as Stacy mentioned, are not necessarily new. They're the ones already contained in the FAR and the DFARS. But what is new is the assessment and the affirmation requirements. So next slide. So what are the CMMC levels? There are 3 levels, and they go in increasing order of sensitivity of the data. So level 1 covers the protection of federal contract information, or FCI, and that requires compliance with the 15 security requirements in 52-204-21. Step up from that is level 2. That covers the protection of controlled unclassified information, or CUI, and that requires compliance with the 110 security controls in NIST 800-171 Rev 2. I know some of you know there is a Rev 3 out there. Currently, the requirement for CMMC is Rev 2. The DoD has said that there will be another rulemaking to bring in Rev 3 when they decide to do that. So it's Rev 2 for now. Level 3 is kind of a step up from level 2. It still covers controlled unclassified information, but it covers CUI that DoD itself has determined requires enhanced protections due to the sensitivity of the data. So level 3 itself is going to be applied on a case-by-case basis. The general guideline from DoD now is that it's going to apply to the protection of mission-critical or unique technologies and programs. So the more sensitive or the more unique the CUI to be protected, the more likely it is that DoD is going to require a level 3. So level 3 itself requires compliance with NIST 800-171 Rev 2, so it requires level 2 compliance, and it requires compliance with 24 select requirements from NIST 800-172. Next slide. So now we're getting into the meat of the CMMC program. What are the CMMC assessment requirements? So there are levels, there are 3 assessment requirements. The first one, the lowest one, being self-assessment. So for level 1, the protection of federal contract information, contractors conduct a self-assessment annually against the security controls in the FAR and enter the results in the supplier performance risk system. There is a level 2 self-assessment that does apply to some CUI. That one is going to be conducted by the contractor every 3 years against the 110 security controls from NIST 800-171. Again, contractor entering the results in SPRS. So when is a level 2 self-assessment going to be required? The guidance from DoD right now says level 2 self-assessments are going to be required when the anticipated CUI under a contract falls outside of the Defense Organizational Index grouping on the National Archives CUI registry. So if you go to the National Archives registry, there are a whole bunch of different categories of CUI. There is defense category, but there's also export controls, privacy, law enforcement, things like that. The level 2 self-assessment is going to apply when the CUI under the contract is outside of the defense category on the CUI registry. But if the CUI is within the defense category on the CUI registry, we bump up to the next assessment level, the Certified Third-Party Assessment Organization, or C3PAO assessment. So this applies to level 2. So again, it's an assessment of compliance with the NIST 800-171 requirements. It's conducted by the C3PAO every 3 years, with the results entered into the CMMC Enterprise Mission Assurance Support Service, or the EMAS system. And again, this is where the CMMC program is really taking off, because this is the independent verification and validation of compliance with the security controls. Finally, the highest level of assessment is the DCMA, Defense Industrial Base Cybersecurity Assessment Center assessment, or DIBCAC. This one's conducted by the government itself. So for those contractors that have already received level 2 C3PO certification assessment and need to move up to level 3, they contact DCMA, DIBCAC to perform the assessment on their systems. This one is also conducted every 3 years, and the DIBCAC enters the results again in the CMMC EMAS system. Next slide. So Stacy already mentioned POAMs. Just to fill that out, our plan of actions and milestones acceptable under CMMC? And the answer is, of course, it depends. So for CMMC level 1, no, they're not permitted. When at the time you conduct your self-assessment on level 1, you have to meet all 15 controls to receive a final level 1 status. But for levels 2 and 3, POA&Ms are permitted with several caveats. The first being that the initial assessment, the contractor has to score high enough to receive conditional status for the applicable level. The program rule states that you can achieve that with a score of 80%, which translates for level 2 to a score of at least 88 out of 110. And for level 3, you need a perfect level 2 score and a score of at least 20 out of 24 level 3 controls. The second caveat is you can only use it for certain security controls. This is kind of a two-part caveat. The first being for level 2, you can't use a POA&M to meet controls with a value greater than 1. So there are 5-point, 3-point, and 1-point controls. POA&Ms can only be used to meet 1-point controls during the conditional status period. In addition, the rule lists several express requirements of security controls that must be met in order to achieve conditional acceptance, because they cannot be used they cannot be satisfied using POA&Ms. So, but assuming you've met conditional acceptance, you've met the required controls listed in the rule, you can receive conditional status and meet the remainder of your security control requirements during a 180-day period under a POA&M. The important part here, and Stacy mentioned one of the drivers behind the POA&M CMMC program, was there has to be an end date for POA&Ms. They can't go on forever. So under the rule, contractors have 180 days to close out POA&Ms. And that means there has to be a second POA&M closeout assessment to verify that those security controls are now met. That closeout assessment has to be performed by the same organization required for the original assessment. So if a C3PO conducted your level 2 assessment, the C3PO also has to conduct the POA&M closeout assessment and verify you have met those security controls and closed out the POA&M. If you don't, if you either fail the POA&M closeout assessment or you don't schedule your POA&M closeout assessment within 180 days, the consequence now is the expiration of your conditional status. So you're basically back to square one, and any contracts that you received on the basis of that conditional status are subject then to termination. Next slide. So what are these CMMC affirmation requirements? This is the second major part of the CMMC program. So under the rule, an affirming official, which is essentially a senior level representative within the contractor's organization responsible for overseeing CMMC compliance and continuing compliance with the requirements, has to provide the CMMC affirmation at 4 different time periods. Upon achievement of a conditional CMM status, upon achievement of a final CMMC status, annually following a final CMMC status date, and following a POA&M closeout assessment. The one I want to focus on here is the annual affirmation of compliance. I already mentioned that for level 1, level 1 self-assessments have to be conducted annually. So your annual level 1 self-assessment is going to be your annual affirmation for level 1. But level 2 and 3 only require an assessment every 3 years. In those intervening years, annually, the contractor still must submit an affirmation affirming that they are in continuing compliance with those security controls. So it's important that even if you're level 2 or level 3, that you maintain a current annual affirmation of compliance. The affirmations are all submitted by the contractor in the SPRS, and the DoD is going to rely on the SPRS system at the time of award to assess compliance with the solicitation contract requirements and verify you meet the assigned CMMC level for that contract. Next slide. To whom does CMMC apply? The short answer here is pretty much everybody in the defense supply chain. So the goal here, as Stacy mentioned, is the protection of information. And the important part is not at what level it exists, but simply who has the information, because DoD wants the information protected. So under the rule, the CMMC program applies to all DoD contract and subcontract awardees that process, store, transmit information that's either FCI or CUI on contractor information systems and the performance of a DoD contract. The only exceptions for this are contracts exclusively for COTS items and contracts below the micro purchase threshold. There are no exceptions for commercial item contracts, no exceptions for small businesses, no exceptions for non-US organizations. Everyone else has to meet the requirements on the schedule of everybody else. DoD has said no waivers, no exceptions. What that means with regard to prime and subcontractors is prime contractors are tasked with ensuring that subcontractors meet and comply with the CMMC requirements. So when awarding a subcontract, the prime contractor makes a determination as to the applicable CMMC level based on what information the prime is going to be providing the subcontractor and what CMMC level is required of the prime. So if the prime contractor is a level 2 C3PAO, so they're going to be receiving CUI within the defense CUI category, then the subcontract could still be level 1 if the prime contractor is only going to be providing the subcontractor with FCI, federal contract information. But if the prime suspects that it's going to be providing the subcontractor with controlled unclassified information, then the subcontractor also has to meet the level 2 C3PAO requirement in order to be awarded the subcontract. So again, prime contractors are the ones who are responsible for enforcing subcontractor compliance, but DoD has said they're not going to have access to the SPRS system like the government does. So prime contractors are going to have to find other ways to independently verify subcontractor status prior to award and during award of subcontract. So next slide. Okay, finally, when does CMMC start? As Jamie and Stacy already discussed, the CMMC program has started already. With the finalization of the Title 32 Part 171 rule, the CMMC program went into effect on December 16, 2024. So right now, you're free to go out, start getting your C3PAO assessments, and it will be compliant, and you'll be ready when the program actually starts getting implemented into contracts. That will start, as Stacy said, with the finalization of the DoD contract rule modifying Title 48 and the DFARS clause 252.204.7021. That will be the clause that actually implements CMMC requirements in contracts and will formally impose those requirements on contractors. So once that contract clause rule takes place, it'll kick off a 4-phase implementation phase or process. I have the data listed here on the slides. Essentially, each phase will be 12 months from the preceding phase, and it will gradually ramp up the assessment requirements. So phase 1 will be level 1 and level 2 self-assessments. Phase 2 will be level 2 C3PAO assessments. Phase 3 will be level 3 DIBCAC assessments, et cetera, until we get to phase 4, which is full CMMC program implementation, all DoD solicitations and contracts, all option periods. So when that happens, everyone will be expected to comply all the time. So with that, I'll turn it back over to you, Jamie, and the rest of the panel.
Great. Thanks so much, Tyler. We know that's a lot of information, so we will definitely be sharing our slides with everybody after the presentation. But I found that super informative. Next up, we're going to have our friend Terry McGraw speak. Terry has a ton of experience in the cyber world over several decades. So Terry, why don't you go ahead and introduce yourself and tell us a little bit about why the defense industrial base is a primary target for cyber threats today.
Sure. So Terry McGraw, I'm the CEO of Cape Endeavors Incorporated. We are largely a subcontractor to Gray Analytics, who's also on the panel today. We provide secure enclaves, RPO services, and CUI identification scanning capabilities on behalf of Gray customers. So we do that as a sub to Gray Analytics. Why is a DIB a target? Well, I think Stacy, pretty much enumerated that pretty well. Look, you don't go after your enemy where they're strongest. You go after where they're weakest. And sadly, in manufacturing base tends to lag behind other environments that have a more rigorous compliant framework that they have to attest to, i.e. the financial networks and health, et cetera. But I'd be remiss if I didn't talk about commercial cybercrime as well. In almost every ransomware attack, data theft is a near ubiquitous component of the extortion tactics for cybercrime. So when you have cybercrime activity, data will leave your environment, and if it's whether it's going to the nation state of China or it's going to a threat group RIOC, you still have data that left your environment, and it may well contain DoD data. And so it's not just nation state threats we have to be concerned with. In fact, if you just look at likelihood and prevalence, the attacks of the cyber criminal networks are far more prevalent. And so that is a component that we have to deal with as well, to which this framework and the compliance mechanisms and the actual security controls implemented do very, very well against remote attacks.
Great. And when we were having our prep sessions, you used the term "a market for lemons."
Yeah.
Can you explain a little bit about what you mean by that, and what makes cybersecurity in the defense industrial base a market for lemons, and how is DoD addressing that?
Thanks. Yeah, so George Akerlof, the economist George Akerlof, in 1970, wrote a transformative paper where he described an asymmetric information marketplace. And he used the used car market as an example for this. This is a market that arises when the seller has all the information, the real information about the quality of the good or services to be sold. And those wanting to buy that service or product have to infer. But you can just sort of look at it. When you're buying a used car, I can see it. I can check for rust, et cetera. But I don't really know what the inner workings of that car is doing, and I don't know how it's treated, et cetera. And sadly, the cybersecurity market has a lot of those same asymmetric information components. When you're a buyer of cybersecurity services, when you're going to hire someone to help you improve your own security efficacy, you don't really know the efficacy of that technology or service that you're buying just by the market texture, or the claims of the purveyor. You have to actually, and oftentimes, acquire the technology, hire the service, and then make the determination based on empiric evidence. And that is a very much an asymmetric marketplace. So when you look at the cyber AB, this is the marketplace or the mechanism that the DoD put in place to provide the market and the structure around who can provide assessments, who can provide consultative services to get ready for the assessment. They built a marketplace, and it provides standardization, training, assessing of the assessors to ensure that there is at least a baseline understanding and a consultative expert level that is a minimum to be considered in that marketplace. And so it's the government's way, or the DoD's way, I should say, of trying to bring transparency and standards to the market to reduce that asymmetric information that's taking place in cybersecurity markets writ large.
It makes sense. And let's talk a little bit about strategies for compliance. Stacy touched on this a little bit. She mentioned, there's an enclave model, there's an enterprise model. How do you think companies should think about the right approach to achieving CMMC compliance?
Yeah, look, there's three general approaches that the vast majority of folks will have to undertake. Number one, deciding to uplift your entire network to become compliant to the CMMC framework in 171. There is building an enclave where you handle the CUI appropriately, and it's a subset of that environment. Or if you have a very legacy environment, it's old or it's been, heterogeneous by merger and acquisition, you just got a lot of stuff everywhere. You may want to build a greenfield where you build a new environment and then you sign out Friday and you sign into the new environment on Monday. Deciding which of those is right for you as a corporate entity is really based on, what percentage of your revenue is derived from DoD contracts. Is it a lot? Is it a little? What's the effort worth to you in terms of maintaining your annual revenue? How many of your employees actually interact with CUI? Did they process it, store it, et cetera? They interact with it. What kind of CUI do you handle? Is it just CUI or is it CUI specified like ITAR or NARA? In which case you'll have to have additional controls around whether that be you choose a GCC or GCC high cloud environment, for example, to build your environment in. And then do you have non-US persons that participate in your network that may come in contact with CUI, even if not by design? Meaning, do you have cybersecurity professionals that are outside the U.S., et cetera, or IT outsourcers that are outside the U.S. who may have access to that network and interplay with CUI, even if indirectly? And so those are considerations of what approach is best for you. In large, like global enterprises or large heterogeneous environments or companies that have a large commercial business as well as a government business, oftentimes the enclave is the fastest, most cost-effective way to become compliant, but not all enclaves are created to equal.
Gotcha. And Stacy also mentioned that there are companies out there that can partner with contractors to get compliant, to help contractors come into compliance. So what do you think companies should be asking during that selection process to determine who to partner with?
Yeah, the marketplace is a great start, right? Like first things first, when you're Google searching or you're just web searching for an RPO, registered practitioner organization, or an assessing organization, you will get a lot of results that make a lot of claims. First, go to the marketplace, the Cyber AB marketplace. Start there, right? Okay, and so at least then you're getting people that have invested the time and energy and money to becoming certified with the Cyber AB, so they're authorized to provide those services to you in the market. And then, not all of those folks are created equal either. Don't be afraid to ask them, how many companies have they brought successfully through an assessment, and what was the SPRS score at the completion of the assessment, right? I mean, don't be afraid to say, have you done this before, or how many have you done, and what was the outcome of that? So understanding who you get. When you decide if you're going to build an enclave or pursue an enclave because it makes the most sense for you, determine what they do, what you do. Is this a turnkey service where they're doing everything on your behalf? They're building the documentation, they're helping you with the attestations and the assessment, or is this, hey, I build you an enclave, I hand it over to you, it's all yours? Or is it some inherited capabilities model where you do some stuff, they do other things? You really have to understand what that provider is actually providing so you can make an informed decision of total cost of ownership and what you're going to be expected to do yourself prior to the assessment. And so not all enclaves approach that the same way. So ask the questions of the consultants of their track record, have their approach to getting you ready, and then whether or not and how often they've done this before.
Okay, great. And finally, if you can answer this in 1 minute or less,
I can.
just so we stay on schedule, what is the empty enclave syndrome, and how do companies avoid the impacts of accidental spillage of CUI, which would become a reportable event under the CMMC rule?
Right. Okay. So this is actually a near and dear hot topic to me. We spent a lot of time in CMMC talking about, okay, we have to build, we do process, people, and technology around building an enclave that is resilient and hardened enough to handle the DoD data marked CUI. But let's assume you're in an environment and that enclave you just stood up to actually become compliant. Where is all your CUI now? I will bet you it's not in that new enclave, right? It's probably somewhere in your network. And if you've got, gigabytes, terabytes, petabytes of files, do you have a methodology to identify that and bring it back to where it needs to be in this enclave that you just spent money and building to attest that you're doing it? Now you actually have to go and bring the CUI into that environment so you are now compliant with what you just told the government you are. God forbid you should get popped with a ransomware attack, before you've moved that data into the enclave, and now you have DoD data outside of just being assessed, right? That's when we talk about are we really up against the Civil Fraud Act. And so you do need a plan. Now, if you have articulated a CUI maintenance plan, meaning I know that I'm going to treat this like vulnerability management. I got to patch my systems. I've got to continually patch, or I have to continually scan for CUI that's not where it's supposed to be, because people do accidentally email something to you. It might have a CUI in its attachment. If you want to avoid having that to be a reportable event every time it happens, you have to have a clearly enumerated policy and procedures around how do I identify it? How do I treat it? How do I ensure it's where it's supposed to be? How do I remediate it once we found it, to ensure that there's no vestiges left of it in my environment? And how do I do that routinely to ensure that that's an ongoing process? That way you avoid the one-offs of, oops, I now have a reportable event. You have an enumerated policy plan and procedure, and you have archival evidence to show you're doing it. And so that way you can maintain your compliance throughout the year, and avoid having that data not be where it's supposed to be.
Great. Thank you so much, Terry. That's super informative. We're going to turn it over to Brandon Sessions now. And Brandon, if you could just introduce yourself briefly. Well, I guess you already did, but if you want to reintroduce yourself. And the final rule uses the term organization seeking certification, or OSC, which are all the contractors out there listening in. So maybe tell us a little bit about where does an OSC start in this whole process when we're talking about compliance?
Sure. Thanks, Jamie. And again, I'm Brandon Sessions. I'm the Vice President of Commercial Cybersecurity for Gray Analytics. And we're not just an advisory firm. We're also a C3 PAO. As Stacy and others have mentioned a little bit earlier today, we're a certified assessment organization in the defense industrial base. And so OSCs, the biggest thing that they need to think through is, do they have a contractual requirement to protect CUI? So the first they need to do is review their contracts, look through the information and understand if they have that in there. But it's not just their existing contracts, it's the new solicitations that are coming up. So as Tyler mentioned a little bit earlier, there's going to be a phase in. And we actually just saw here recently, there were some initial contracts that came out that talk about CMMC, either you're certified and or that you are on the schedule to become certified by a third-party assessment organization, so that you could use points to be able to be successful in getting that solicitation. So that's number one. What we found is that a lot of organizations just don't or haven't had the time to understand their contracts and to do different things. So we at Gray Analytics are going to release a new tool that we've developed this next week. It's called Gray Certify. And what that does is it allows organizations to answer some questions to truly understand if they need to move forward with an assessment or not, if they're really prepared to move forward with an assessment or not. But we're trying to remove the gray and make it really black and white for organizations to understand, right?
Makes sense. And how important is it for an OSC to think about scoping and preparation, in terms of compliance?
It is so important. So as you've heard earlier in the conversations from other panelists, they talk about, are you going to lift your entire environment, or are you going to have an enclave to do things? And both of those options, totally viable. You heard Stacy a little bit earlier where she mentioned an organization getting fully compliant in 2 months, right? And then moving forward to an actual assessment. We've utilized CAPE Endeavors to do that for us. We've done that for organizations that, for other organizations that didn't do the enclave, that done the full environment. But what we've seen is that, firms need to truly understand before they start spending dollars, what is their scope. So Terry mentioned a little bit earlier about, trying to identify CUI inside of an organization. So if you understand how many people in your firm are interacting with CUI on a daily basis, you can make a very educated decision going forward on what is the best approach to become fully compliant. Once you identify the organization, and or if you're going to do it yourself for the preparation piece, If you don't know where CUI is in your environment, use a tool that, like Cape Endeavors has or some other firms have that actually will allow you to locate the CUI inside of your environment to truly know how many users that are impacted, right? That's first steps, I feel like. Second steps, you've now decided that you're going to either lift your entire organization or you're going to do an enclave. The other thing that comes into mind is there anything contractually that's pushing you to make a decision sooner rather than later? Meaning, are you trying to prep for a new solicitation coming out? Well, if you are, and that solicitation is going to drop in the next 2 to 3 months, and you're thinking about lifting your entire organization, we've seen that organizations, if they're trying to lift the entire organization, it takes greater than 6 months, especially like Stacy said earlier. So an enclave is probably going to be your best approach on moving forward with that. And again, when you're evaluating, make sure that you check with the organizations that have been successful with getting through other firms with their solutions back into the joint surveillance time period, and even today in the new world of C3PAO certifications.
Right. Yeah, and that's a good segue to the next question, because Terry discussed it and you just mentioned it too, about what firms should look for in a partner to help them get compliant. What about looking for an assessment organization, an actual C3PAO? What should contractors look for when they're picking the C3PAO to use for their actual assessment?
Yeah, I think you said it best. Partner. That's number one. You need to find a good partner. You only have a limited time on the phone with companies as you're doing the interviews, right? So you have maybe 30 minutes, an hour, a couple hours to actually interview the team before you make your decision on moving forward. You need to figure out that they're saying the right things in the manner of that they are going to be there in partnership, that they are going to be flexible with schedule, that they don't have anybody on their teams that have egos, big egos. Now, I know that sounds silly, but it really matters in the fact that we were involved with joint surveillance certifications, et cetera, where we saw and we were sitting on the other side of the table where sometimes things get to people's heads, the power gets to their heads. We at Gray Analytics love to say that we have nobody on staff that has that mindset. We're really there because we put the people first. That's what matters. There's a people part to this that people need to understand and that organizations need to take into effect, because there have been tens of thousands of dollars, if not hundreds of thousands of dollars spent to become compliant. And that needs to be thought of at the same time of when you're sitting across the table with trust but verifying, asking questions.
Makes sense. Makes sense. And then, in terms of the scheduling of assessments, obviously the rule came out in October. We're still waiting for the DFARS rule, but what are you seeing in the market in terms of how quickly these assessments can be scheduled?
Yeah, so I feel like some people think that there's FUD in the marketplace, right? There's fear and uncertainty out there of organizations saying you have to schedule today. But truthfully, it's a numbers game. So as of today, I looked at the Cyber AV marketplace before getting on the webinar. There's only 67 organizations that can actually perform assessments. There are over 75,000 firms that need to be certified. So it's truly a numbers game. We are seeing schedules fill up very quickly. Most organizations are trying to, assist organizations, but I go back to the flexibility part. Getting on the calendar with an assessment organization can be simple. And then you take your time to prepare and do everything else that you need to do if it's done right. Meaning, we'll schedule organizations into Q3, Q4 because they're not ready to go through assessment yet, because we want them to have enough time to be truly prepared for that. Go back to the old adage, it's better to measure twice and then cut once, right? That's what we try to tell organizations when we talk to them, that's how we need to move forward.
Gotcha. That makes sense. And Stacy touched on this as well, but what's your view about whether firms should be working on compliance now and like you just mentioned, getting assessments scheduled, right, or should we wait until the DFARS rule comes out and then start acting? What's your view?
Yeah. So again, it goes back to the FUD where people think that there's fear and uncertainty. We all as experts have sat here today and said that it takes months and months to actually get fully compliant. when you factor back in that by the time you're actually fully compliant, that then you go find an assessor to actually certify you, and then you put the numbers game into all of that, it's going to be extremely hard. One thing that we're seeing, though, is, and I think Alex is going to talk in just a minute or two about the Civil Cyber Fraud Initiative and how that kind of plays into this, is that you have the organizations that are seeking certification, and some firms, unfortunately, have said that they're doing things that they're really not doing. So when you've got civil cyber fraud and you've got the contractual things coming out, it just is a perfect storm. That everything is pushing in that direction of everybody needing to be fully CMMC compliant. So if you're delaying on doing those things today, you're just delaying the inevitable.
Makes sense. Makes sense. And that's a great segue, because we actually are going to switch gears now and talk a little bit about what happens, what are the potential consequences of non-compliance, both from the False Claims Act perspective, and then a little bit after that from the cyber incident perspective. So my colleague, brand new colleague actually, Alex Canizares, who joined us at the firm just a little over a week ago, is going to speak about the False Claims Act. And so Alex, why don't you just introduce yourself and take it away?
Thanks, Jamie, and thanks everybody for sticking with us. I'll try to move briskly through this part, but so Alex Canizares, I'm a partner at Vinson Elkins in the government contracts practice group, and my practice focuses on government contracts litigation, investigations, and counseling, including False Claims Act defense, which is what I wanted to spend a few minutes talking about, related to cybersecurity in particular. So let's go to the next slide. So just as a sort of refresher for those of you who are probably familiar with the False Claims Act, this is a Civil War era statute. It has become an enforcement tool that is used in a wide variety of areas for government contractors. And it's a civil remedy as opposed to a criminal statute, which gives it a lot of power because the burden of proof is essentially less than what you would otherwise have to show in a criminal case. And basically what it does is imposes liability for knowingly presenting or causing to present false or fraudulent claims for payment to the government. The damages are trebled, in other words, 3 times the government's losses, plus per claim penalties ranging from $14,000 to $28,000. And a majority of the recoveries from year to year under the FCA are originated from qui tam lawsuits, and these are brought by whistleblowers, also known as relators, that file complaints under seal in district courts around the country. DOJ then conducts an investigation to determine whether or not to intervene and take over those cases. And relators are then entitled to recover anywhere between 15 and 30% of any recovery that the government gets. And so that really incentivizes what we're seeing, especially in the cybersecurity area, where there is an increased number of cases being brought by people inside companies, although not exclusively, alleging some sort of fraud with respect to the cybersecurity compliance that company is obligated to carry out. So, as just a data point, DOJ recovered $2.9 billion under the FCA last year in settlements and judgments. That included a record high number of new qui tam suits that were filed, 979. That's a really big number, and I think that was partly driven by pandemic-related fraud cases. But the point there to take from that is there are a lot of cases in the pipeline. These investigations often take years, and I think the uptake for that is that there's going to be a lot of cases that are underway or being unsealed for the foreseeable future. The new administration has signaled it intends to pursue FCA enforcement vigorously. There have been a number of public statements from DOJ officials to that effect. There have been a couple of settlements in the cyber area that I'll touch on in a moment that have been released in recent weeks. And, FCA enforcement tends to be relatively robust from one administration to the next. If you look at the statistics that DOJ issues every year, you'll see rather static, continuity on the FCA front. So the signs are that cybersecurity and False Claims Act enforcement will be around. It'll be an area of focus for the foreseeable future. So let me spend a moment just talking about the DOJ Civil Cyber Fraud Initiative and some of the things that we're seeing in that area. So this is an initiative that was launched in October of 2021 by the then Deputy Attorney General Lisa Monaco. It was part of a cyber review that DOJ undertook. And basically what it seeks to do is use the False Claims Act, which is a tried and true remedy for pursuing fraud, not only with respect to procurement for any entity that receives government money, and use that for cybersecurity. And so it's their intention is to hold government contractors and grant recipients accountable for putting U.S. information and systems at risk. These investigations are being led, this initiative is being led out of the civil fraud section, which is part of the civil division in the commercial litigation branch at DOJ. And they are coordinating with U.S. attorneys' offices around the country, offices of Inspector General, and with respect to DOD, the DIBCAC, and other experts with cyber expertise. There are a couple of different theories that DOJ has highlighted that they're interested in. Knowing provision of deficient cybersecurity products or services. Second category, and this is really where we've seen a lot of activity, are cases alleging that there's been a misrepresentation of cybersecurity practices or protocols. And then third, violating an obligation to monitor or report a cyber incident or breach. And so these are just three not exclusive categories of cases that DOJ has highlighted its interest in. Let's go to the next slide. So I'm just going to spend a few more minutes on this. Where are we in this initiative? So we're now several years in, but it's been enough time now that we've seen a number of settlements, that we're starting to see some trends and some data points for what kind of cases DOJ is interested in. And I think at a high level, you could say DOJ is really probably most interested in cases where there has been a real breakdown in terms of compliance. And we've touched already on what the scope of the obligations are under the DFAR 7012 clause and then under CMMC. But a lot of these cases are kind of falling into a couple of different buckets. One bucket is alleged knowing failure to implement the controls. So the NIST 800-171 controls, and related to that would be an allegation that there's been a misrepresentation of the extent to which a company is implementing those controls. Another bucket that we've seen a significant number of cases in relates to privacy information. So as opposed to government data, we're actually seeing the Civil Cyber Fraud Initiative applied to circumstances where a contractor is required to safeguard privacy information, personal health information, and they fail to do that in some respect. And I won't spend too much time on those cases, but those are notable too. For many contractors, they're required to maintain some sort of personal information from people to one degree or another. So there's been 10 settlements total, and 2 of which were just issued recently under the new administration. There's another case that's in active litigation involving Georgia Tech University, which is a very important case to watch. A recent case that I wanted to highlight here, just for you all to spend some time looking at, is a case called Morse Corp. This is a settlement with a defense contractor very recently on March 26th. $4.6 million settlement. And this is illustrative, I think, of the kinds of cases that we're seeing. It's a defense contractor that had Army and Air Force contracts. They were subject to the 7012 clause, the 7019 clause, and they were, the relator in this case filed a lawsuit alleging that there was a number of violations of these contractual requirements. And this person was the head of security inside the company. He was also the facility security officer. He filed the qui tam lawsuit. DOJ investigated, as they're required to do, and they intervened for purposes of reaching a settlement. And I just wanted to mention a couple of things about the allegations in this case that I think are relevant for you all. One is, one of the allegations that the company acknowledged in the settlement was that they had used a third-party provider to host their emails that did not meet the FedRAMP moderate baseline. And so under the 7012 clause, there's a requirement for cloud solutions. If you're going to use a cloud provider for CUI, it needs to be at least FedRAMP moderate or its equivalent. And this allegation is relevant. I think increasingly now we're seeing contractors using cloud as a resource to host their CUI. So that's one notable allegation. Another one that's really relevant here is under this settlement, this contractor acknowledged that they had done a self-assessment. They submitted their score to SPRS and self-attested that they had implemented 104 out of the 110 controls. Then they got a third-party cybersecurity consultant who came in some significant time later and said, well, actually, the real number that you've implemented is significantly lower than that. It was a minus 142, which is the score when you do the calculations. It was a significantly lower score. And this was converted into essentially a fraud allegation in this case. I think it's really important for people to be mindful of the fact that for many of you who are now going to go into the CMMC process, you've already submitted those scores, and you really want to be mindful of what have we represented our scores to be in the past, and how might that maybe create some risk if we're going to come back and change, our scores down the road. A couple other things to mention is, so CMMC, I think, is going to change the way these FCA cases are brought to a degree. I think kind of cuts both ways. On the one hand, I think CMMC can reduce risk for contractors because you are going to have a third-party assessment, at least if you're level 2, and that is basically a verification that you're compliant. The difficulty or the challenge there is that that's really a snapshot in time. I mean, if you have an assessment that says you're compliant, the question is, are you continuing to be compliant? And with cybersecurity, it is a constantly changing landscape. The threats are changing, and the compliance and your environments are constantly changing. So that's a difficulty. And the other point I would make on CMMC is that there's an increased number of new requirements that Tyler mentioned for annual attestations and verifications that are basically representations. And any time that that's not substantiated or allegedly false or misrepresenting, that could create an FCA allegation. So let's go to the next slide, and I'll quickly wrap up before passing it to Zach. A few takeaways from this. So, I would encourage you to think about the False Claims Act, generally, but also with respect to CMMC and kind of getting ready for your CMMC assessments, thinking about the representations you've made, as I mentioned in the past. Review your contracts for FAR, DFARS compliance or the kind of contract requirements you have. Assess your terms with your subcontractors and vendors, external service providers. And really, with the False Claims Act, because it has a knowing component to liability, thinking about documenting your decisions, right? Good faith, reasonable interpretations should be documented, not only with respect to the implementation of 800-171, but thinking about, what's in your system security plan, what does your internal documentation reflect, and be mindful of those sorts of decisions. And as I mentioned, these self-assessed scores that you've submitted to SPRS are an FCA risk. They have to be corrected timely if they're flawed in any way. And also, just as a final reminder, for those of you with FAR contracts, you very often are subject to the mandatory disclosure rule. If you determine you've got credible evidence of a False Claims Act violation, that is something that needs to get disclosed to the government under that clause. And so an important piece of any sort of compliance is being careful of that rule. Okay, I think I will wrap up there and turn it over to Zach for the last portion. Thank you.
Great. Thanks, Alex. And that's super informative. Zach, can you just tell us a little bit more about what could happen if things go wrong and a company's compliance is not up to par, and maybe share some lessons learned from what you've seen on matters where things have gone wrong?
Sure. Yeah, absolutely. And thank you all again for joining us. This is a great combination between Gray Analytics and V&E. And one of the things that I can say too is we have been shoulder to shoulder with Gray when both when we're building and going through the CMMC compliance process, and I've watched them walk a client through this and seen their work. We've also been shoulder to shoulder with them when things do go wrong. So let me just level set for a couple minutes that we have left. You do not want to be in the situation where you are dealing with a major cyber incident, full stop, and everybody knows that. What can really exacerbate that for you is if you have made a certification or your system is not up to par, and all of a sudden, you are not only dealing with the government, both as someone you are seeking their help, perhaps in investigating a threat actor, in disclosing to them that their information has been taken, but also as your customer, obviously. And that's a situation that I think a lot of companies find themselves in, certainly government contractors, where you're dealing with your commercial customers and they have their own issues. Then you're dealing with a government customer and you're explaining to them, how this happened and why this happened, and it doesn't instill a lot of confidence, depending on the situation. And so I totally agree with everything that you've heard from others today. Is how can you best inoculate yourself from this happening, and if it happens, how can you put yourself in the best position moving forward? And there's all sorts of things you can do, obviously, in terms of backup servers, in terms of making sure you have the most hardened environment possible, being CMMC certified and compliant. But I will tell you that having had to make those very difficult calls with clients to the government, you get a tremendous amount of goodwill from them if you've met their requirements and if you've leaned forward and gone farther than what's required. Because frankly, as I think we started with, our threat actors don't care what your certification level is. They care whether they can get in or not. And so if you are able to meet the government standards, exceed the government standards, and really demonstrate that you are doing everything possible, I think that does go a long way. One of the things I deal with as a white collar practitioner and crisis management person is, when you're being asked, you're going to be asked some, pretty serious questions. How did this happen? Have you stopped that back door? When did you know? What have you done? Is the threat actor out of your system? And what did they take? And how can you be so sure? And those are just really, it's truly the worst. And one of the things that also happens is it brings, unless you have, a separate backup system, unless you are already well ahead of the game, it brings your business to its knees, and it can be absolutely all consuming for months on end to try to deal with these issues. So that is a little bit of the cautionary tale, is you do not want to wait. This is a situation where you want to have your proverbial chimney swept and inspected and dealt with before you have that chimney fire that burns your house down. Let me also touch on just a couple other things in the minute or two we have left. So my former role was as the U.S. Attorney for the Eastern District of Virginia. So that's the district that sits just across the Potomac River from downtown DC, and it's where a lot of the DoD defense industrial base is located, whether that be Crystal City, whether that be just across the highway from the Pentagon in Crystal City, or it out be in the Dulles corridor, or elsewhere, or down in some of the areas in Virginia where we have large infrastructure, like in Newport News with shipbuilding, or down in Norfolk where we have the Norfolk Naval Base. One of the things that I know from my time as a prosecutor and the U.S. Attorney in the Eastern District of Virginia is procurement fraud is going to be a priority. It is a priority in every administration, but I have it on good authority. It will be a major priority of this administration and of that office. And one can see why. We have the Department of Government Efficiency, the DOGE, that is basically an inspector general on steroids. You already heard Alex mention how many qui tam relator cases are in the pipeline. For those who are less versed in qui tam and False Claims Act cases, this is actually a way that the government can recover money. So if your goal, which it seems very clear that this administration's goal is to reduce federal spending, not necessarily increase taxes, and get more money into the public fisc for defense spending, one thing that every politician I've ever run into wants to do is ferret out waste, fraud, and abuse. Well, that's the False Claims Act. So this is not one of those, okay, in the future, you may have to worry that the government's going to come looking. What Alex was describing very accurately is you actually have a bunch of little government agents everywhere in the form of relators who are watching and looking and learning and reporting on these types of issues. It's not just that the inspector general has to be aware of this. It's not just that the government is aware of this. You have, quote, relators, who are people who, basically stand in the shoes of the government and come forward with these types of issues. So We are officially at time. I want to be respectful of all your time, but on behalf of Vinson, Elkins, and Gray Analytics, we really want to thank you for joining us. Please do reach out. You've heard from folks who have the experience and have actually done this, and I can personally vouch for the experience we at V&E have had with Gray Analytics and their team. Thanks so much.